All right, let's get some analysis now, joined by legal expert Melusi Xulu on this matter. Opasha, good to have you, and thank you very much for coming on this evening. It's a full sitting in the Johannesburg High Court. It was a full sitting even previously to discuss the matter of the private prosecution. This one was looking at the appeal, and coming out of this, and of course the judgment in full still to be released, but certainly what we're hearing is that the president acted with an ulterior purpose and an abuse of process is being cited here. Let's go back. So it starts with the president saying President Cyril Ramaphosa was advised of the illegal actions which were taken by prosecutor Billy Downer by releasing those records to journalist Karen Mon. And the president says, no, I took that matter quite seriously, and I suggested that you take it to the Department of Justice and speak to Minister Lamola. And former President Jacob Zuma saying, well, you did not act, and therefore I want to charge you as an accessory after the fact. The first thing that we had to go through there was the nolle prosequi certificate, which the court said it's not valid. It was not meant for President Cyril Ramaphosa. Besides, it was 3 months late. It had expired. So it did not even meet that particular requirement for it to be a nolle prosequi certificate for a private prosecution. What does this appeal now leave that particular matter?
Well, in particular to the nolle prosequi certificate, first of all, good evening to you, Tabo, and the viewers at home. In relation to that, Section 7, Subsection 2, Paragraph A is very clear. If you want to be a private prosecutor, you must get a certificate pertaining that particular accused that you want to prosecute, and you get it from the Director of Public Prosecutions. In relation to the President Ramaphosa, there was no nolle prosequi certificate. So that, in the first instance, was a problem that was that the former president had to encounter. So I think that was one of the issues. And, you know, bearing in mind that the whole procedure or the whole private prosecution was started on the 15th of December, just before the elections, which was actually looked at as an ulterior motive because of the step aside procedure that the ANC has. So it did look as if it was, you know, an abuse of a court process. So in instance, I did not expect any decision that was different from what the High Court decided in June when this private prosecution was set aside.
Yeah, and so, I mean, especially on that matter then of the nolle prosequi, it means there is essentially no private prosecution. And do you see, even if we were to take this matter to the next court, if the president would say, okay, because you have refused to give me leave to appeal, I'll go straight to the SCA, without the validity of that certificate, is this matter going even to be entertained?
I don't think so, because I think maybe the former president was not advised properly about the essence of getting that nolle prosequi certificate, because even if you look at the Karen Mon situation, there was no nolle prosequi certificate. The only certificate that we know, if you even check the last year's news, was the one that was granted on the 6th of June 2022, which was for advocate Billy Downer. So the starting point of this private prosecution, you need a nolle prosequi certificate, where the Director of Public Prosecutions will say they are not going to prosecute the complainant, but they give you that certificate so that you can start the private prosecution. So to answer your question, it's still going to be the same problem. The same problem that the former president had in High Court is still going to have them in the Supreme Court of Appeal, even in the Constitutional Court should we go there, because looking at his strategy, we can see that he will go to the Supreme Court of Appeal. If he doesn't succeed, he will go to the Constitutional Court. The other people may be thinking he's using a Stalingrad defense, but we will see when we get there, because I do expect that he will appeal this decision as well.
Yeah, which is really interesting, the argument that was brought by Advocate Mukhaidobi on the other matter, to say if the courts have already said this is an abuse of process, being allowed to go in at the SCA, would that not be a continuation of that abuse?
It can be, it can look like an abuse of court process, but in any case, it's his right to appeal. And if he feels that he has a chance of succeeding, then he will have to appeal as it's his decision, and he will find out when he goes to those particular courts. But the advantage strategically of taking these cases to a Supreme Court of Appeal or Constitutional Court, it kind of assists him in his fight to say, we cannot start this arms deal case because I'm not satisfied with the advocate who's leading this case. Therefore, we still need to deal with this particular issue because I'm prosecuting him privately. Or I'm still attempting to, because now I'm appealing the private prosecution that's been set aside. So I do not think it's wise to start this arms deal case. So this case keeps being delayed, but eventually it will be a decision that will be made eventually what will happen to the private prosecution if it does appeal though.
Yeah. So the courts even went further to that to say, well, even if you're saying accessory after the fact, which is what you are alleging, you're saying that particular charge rested on a conduct that does not constitute a criminal offense. What is the court saying there? When I was just preparing for this interview, I wanted to find out what happened exactly on the 9th of August. So what happened on the 9th of August was this. Advocate Billy Dana sent an unsigned affidavit just specifying that this case will not proceed because the former president is sick, and he sent that to the registrar in Maritzburg. And when Karen Mon was approaching Maritzburg, or when she was in Maritzburg, she got from the colleague of Advocate Billy Dana that the affidavit is unsigned. So once it's signed, on the 10th of August, she was able to get it when it was a public record now. So when it was a public record, it was not leaked, because when documents are in court, they are for the public to obtain. So she submitted that to the news, I think, at around about 40 minutes past 9 on the 10th of August. So there's no criminal activity to begin with when you have those facts in front of you. Because let us remember, Thabo, that the private prosecution is still a criminal case, and the standard of proving that there's a criminal offense is proof beyond reasonable doubt. So to start with, there's no case if you look at the facts objectively. So this case, I mean, in your view, are there any peculiar, maybe other issues of substantial interest that could possibly have the next or the higher court want to entertain this matter?
In my view, I don't think there is. Like I just narrated the facts around the leaking of the documents. You can see that it was, in any case, something that was obtained through the courts, and it can be something that can be obtained by the public. So I don't think there is any peculiar substantial interest if you look at what is required for a private prosecution.
Melusi Xulu, I appreciate your time. Thanks so much for coming on. There's some legal analysis there on the outcomes of that court matter.